Morning, everybody. My name is Jenny Wilde. I'm a director and solicitor at Ridout Solicitors, and welcome to the second in our series of Ridout's autumn webinars. As you'll be able to see from the screen, this particular presentation is giving more information on navigating safeguarding investigations. And I'm leaving you this morning in the capable hands of my two colleagues, Paul Ridout, who is the Managing Director of Ridouts and a solicitor, and Nythan Smith, who is also a solicitor at the firm. Before we go into the substance of what we're going to discuss today, I thought it would be prudent to just go through a couple of housekeeping points, just so that everybody can maximise what they get out of the webinar. Now, there are going to be a number of issues discussed this morning. The webinar is 45 minutes, so that's a big subject to cover in a relatively short time. But as discussions progress, you may think of questions that you'd like to ask either Nythan or Paul. You are more than welcome to submit questions throughout the presentation just by clicking on the QA button at the bottom of your screen. You should see that there. And we will direct questions to Nythan and Paul at the end of the session. This webinar will be recorded, and the slides and the video will be available on our website and will also be circulated to all participants. The resultant video will also be uploaded onto our YouTube channel. There's a quick plug there. So if you want to access this video and any other of the films that we've produced that cover all subjects around health and social care, then please access our channel on YouTube. That will be helpful also to share the link with people that you think might find this webinar useful. So please feel free to circulate as the email comes or as you find it on our various social media channels. Speaking of social media, if you wish to discuss today's seminar with colleagues, with people in the sector, then please feel free to share on social media as we go through the presentation, or alternatively, afterwards, if you'd like to circulate the link, circulate the slides, you're more than welcome to do that. Now, as mentioned, Paul and Nythan are going to discuss all things safeguarding. They're going to try and shed some light on what safeguarding is, how investigations can impact health and social care providers, and how providers can challenge investigations that appear to be getting out of control. As a practicing solicitor at the firm for over 10 years now, safeguarding has become a bit of my pet project, really. It's a case that I always seem to get involved with, where there have been ridiculous timelines for investigations. We're talking 6 months to a year. Without encroaching too much on what Nythan and Paul are going to say, this can be super disruptive to providers and have significant impact, both financially, commercially, and reputationally. So, in order to start proceedings and give you some basic understanding of safeguarding, I will hand you over to my colleague, Nythan Smith.
Thanks, Jenny. So my brief today is to give you guys an overview of safeguarding. And I'm a solicitor at Ridouts. I've been here for 7 years. And my interaction with safeguarding has been in respect of dealing with Section 42 safeguarding inquiries and where it crops up in respect of CQC's activities, so in inspection reports and in respect of enforcement action. Next slide, please. So what is safeguarding? So safeguarding involves protecting adults from abuse and neglect. And abuse can be as a result of actions that have been taken or actions that have failed to be taken that have resulted in harm or the risk of harm. There are a number of different categories of abuse. We have physical abuse, which could potentially be if a resident has been found with bruises that are unexplained, or residents have interacted with each other and hit each other, or there's a reason why some level of harm has come to someone in a physical manner. For example, pressure sores, the inappropriate use of restraint. You also have things like sexual abuse, which is pretty self-explanatory, and financial abuse, which could be the failure to properly allocate funds and mismanagement of financial monies. We also have issues such as the inadequate nutritional care being provided to residents and the failure to gain appropriate consent. And one of the real key issues that binds all of these safeguarding issues together is in respect of the record keeping that you have as providers. The quality of your record keeping is going to be determinative of whether you're going to be found to have a breach of a safeguarding issue, or whether you can demonstrate that you are providing care in the right way. So if you have poor quality record keeping, the absence of some records which demonstrate that you are providing care in a certain way could be evidence that a safeguarding investigation might prove to say that you have done things in an inappropriate way. And I think it's important at this moment as well for providers to just pause and take a look at who it is that would report concerns. Now, I think they normally fall into 3 brackets. We have malicious complainants. These are people that will complain many times with the prime purpose being to get a negative view on your service. And then we have misguided referrals. This is when people make referrals to safeguarding because of something they've seen or something they think they've seen or they've been told about, but they haven't actually properly interpreted what they've seen. And then we have genuine referrals. That is when someone has seen something or has witnessed an issue which is definitely gives rise to safeguarding arising. Now, irrespective of which level of report we think the person is reporting, malicious, misguided, or genuine, I really do think that you should treat them all as genuine. And if you treat them all as genuine, then you're going to stand yourself in good stead going forward in respect of how you interact with the safeguarding process. Next slide, please. So what are the aims of safeguarding? I think there are 3 main aims. To prevent those at risk of harm becoming subject to harm, to investigate instances of alleged or suspected harm, and to work in collaboration with providers to identify and investigate the risk of harm. So we've got the prevention element, the investigation element, and a very key element is the working in collaboration with you as providers to investigate safeguarding concerns. Next slide, please. So this is a really big one. So section 42 safeguarding inquiry. So this gives a local authority a duty to make inquiries where they have a reasonable suspicion that there is a risk of neglect or abuse, or they have a reasonable cause to suspect that an individual with care and support needs is experiencing or at risk of abuse and neglect and is unable to protect themselves. Now, the key point here is that this is a low threshold for the local authority to meet. So the reasonable suspicion could be anything in reality. Any sort of concern that's raised to the local authority, they can give cause to undertake a section 42 safeguarding inquiry. So it's a low threshold, so you're likely to see a high number of these section 42s, and going forward, it's probably only going to increase with CQC's change in terms of being even more risk-based and risk-orientated. Next slide, please. So in practice, what does a section 42 look like? So it could just be a simple conversation between the local authority and the individual that's subject to the concern, or you as a provider, or it could escalate to a more formal multi-agency arrangement whereby information would be taken not just from you as provider, but from everyone that's involved in providing care to the person that's the subject to the safeguarding concern. It's important that policies and procedures give staff the information that they need to record what is required in respect of any inappropriate care, and give staff the information in respect of what format they need to record that information. And critically as well, it's important that the supervision that you have in place at your service really does manage any safeguarding concern and interacts quite strongly with staff. And the policies and procedures at a provider level should reflect what is in place at the local authority level, which in turn should reflect what is in place at the statutory level. Next slide, please. So I think it's important to keep in your mind Orchid View. It's not just Orchid View, there's others such as Winterbourne View and the like. And there's been a number of tragedies like this where there's been multiple opportunities for local authorities to stop and intervene where instances of negative care have been found, and there have been missed opportunities. So those that are involved in safeguarding view everything as a worst case scenario at this stage, because they don't want to be the local authority, commissioning authority, which has failed to take action where inappropriate care has been found. So consciously or otherwise, local authorities, CQC and others do view safeguarding in quite a negative way. So they presume there's an element of guilt, irrespective of what evidence is put before them. So it's your job as a provider when you're interacting with safeguarding allegations and concerns to really reassure them that this isn't something that's endemic, pandemic within your service, and that you've got it under control. Next slide, please. The CQC angle is very important as your primary regulator, and Regulation 13 provides safeguarding service users from the risk of abuse and improper treatment. So a key part of any inspection will involve an assessment of the provider's safeguarding approach. So it's very important to not only look at the way that you interact with safeguarding, but also to look at how you interact with all your care policies, ensure that your records are adequate and up to date. Critically as well, the outcome of any safeguarding investigation will be shared with CQC. And if it's negative, it's likely to trigger increased CQC involvement, which could involve submission of more action plans, increased inspection activity, or all the way up to, unfortunately, potentially the cancellation of your registration as a provider. Next slide, please. So finally, from me, in respect of procedures, so providers, they do need to follow their own safeguarding policy, which, as I said, should follow the local authority safeguarding policy, which should be published on their websites and will be updated regularly. And as I've said as well, if you are following your own procedures, not just in respect to safeguarding, with all of your care and responsibilities, you're likely to be in good stead. You really need to ensure that you have a safe workforce and staff have received relevant training in safeguarding, and that they know how to report concerns. But the biggest point I really do believe is in respect of the evidence that is likely to form the substance of any safeguarding concern is likely to lie with you. So if you have adequate record keeping, adequate auditing, and you're on top of managing the care that is being delivered at your service, you should be in good stead to knock out any safeguarding allegations as and when they arise. That's all from me from now. So I'd just like to pass you over to Paul Ridout, who will speak to you more about how to manage safeguarding investigations. Thank you.
Good morning, everyone. Paul Ridout here. I'm the Managing Director of Ridouts, and I lead the team which specialises in the health and social care sector, and particularly in managing all kinds of operational activities within care services and care homes in the care sector. Next slide, please. We talk about opening the floodgates. One of the problems with a safeguarding inquiry is that until the Care Act of 2014, it was not actually the subject of any statutory involvement. And so local authorities have taken upon themselves to issue safeguarding inquiries against care homes, really against anyone else, in a way of putting themselves into a second regulator position, which sometimes annoys CQC and creates a duplicity of action. And a concern or an allegation which can arise can snowball from a small issue into a wide-ranging investigation. And very often there will be a quick decision to accept the facts which are alleged and move forward to say this creates a system. And then you have an allegation that there is systemic abuse in the home because of a number of issues that have arisen, which may in and of themselves be unsurprising, may in and of themselves be relatively insignificant to the provider and to others who work in the home. If you do not properly challenge the investigation at the correct stage, it can result in lasting damage, because although there may be a tendency to say, let's just go with the flow, let's work with it, let's work with the local authorities, because that way we will get a better and a more thorough relationship. That is dangerous, because if you do not challenge things that you say are wrong, they will rapidly become the perceived wisdom as to fact, even if they may not be. So it's really important that you take a view early on about whether what is said is correct, whether it's partially correct, or whether it's completely wrong and you need to stand up to the allegation. There's been a tendency for local authority investigators and others to accept what is said in the safeguarding alert. And in particular, that comes from anonymous whistleblowers. Anonymous whistleblowers are an important source of information about the way in which care homes are run, but they must be treated with a degree of skepticism where they're not revealing their name and where the allegations cannot be immediately substantiated. Increased scrutiny from local authorities, CQC, and now the press could lead to action being taken, or even rumours being circulated, which can be extremely damaging to the reputation of a particular care home. And we all see that all the time. May I have the next slide, please? Why would you challenge, as I was saying a moment ago? Well, it's hugely important to your reputation. Reputation is everything. It's often said that reputations take a lifetime to build and a few minutes to destroy. If the issue becomes one that gets out into the media, it alerts CQC, although they wouldn't like to hear me say this, CQC are a bit of a media hound. If they think there is any prospect that the press or members of the public will be suggesting that CQC have been ineffective, and then they will step in and ram their force and their strength behind the investigation and behind what's going on. So your reputation hangs by a thread. All the things that Nythan has said are absolutely correct. Your records, your staff, your ability to deal with the allegation, to accept it if there is a problem, to recognize whether it's a system or whether it's a member of staff who's made a mistake, or may even be a rogue member of staff. Once that reputation starts to be besmirched, there will be financial implications. The number of referrals may dry up. People may cease to pay their fees. Local authorities may intensify the amount of action and interest they take, and this may involve incurring costs, both in terms of consultant experts and lawyers and maybe even accountants. As Nythan said, ensure there's an accurate record of the incident, and as soon as matters arise, take steps to investigate for yourself what has happened. You as providers are the most important person in the safeguarding inquiry, apart from the alleged victim, because you are the ones whose business is concerned, and you are the ones who need to take action and need to be sure that there is nothing here that needs to be reversed. And it's also a very good opportunity to showcase your good practice and to showcase what you do. So these are the reasons, and these are the beginnings of the steps that you take in order to protect your reputation. Next slide, please. How do you challenge? It may be difficult. The local authority may be minded to skip over the details of the allegation, treat it as true, and then move on, assuming that you have that your service has committed a safeguarding breach. Then you must insist, even to the point of firmness, on disclosure of what the allegations are and of all the details that lie behind those allegations. Without that disclosure, you're not in a position to investigate, and the local authority are either themselves short of information, or They may very well have the information, in which case there's no reason why they shouldn't tell you. They may protect information sources, but they can tell you what the allegations are in a sufficient form for you to answer. You should engage and provide information to the inquiry. Always go to the meetings. Take a note taker. There's a long history that the chairman of the committee's note taker writes as, often a self-serving and often a partial report of what has happened. If you take your own note taker, then that will help to keep the meeting honest. Conduct your own investigation. It says here if there's no police involvement. Very often the safeguarding team will say, don't investigate, stop, we don't want you to do anything. They have no statutory right to do that. Of course, you must listen to them, but if you need to find out the facts, you need to find them out quickly. And whilst you want to maintain a good relationship with those from the local authority, there is absolutely no reason why you have to withhold your own investigations, which may be central and important to your own action and steps and how you are seen to relate to this. If you just leave it pending others' investigations, months and weeks may go by. Now, there is an exception. If the police are involved and the police say that they are going to take over and they are not, and they don't want you to investigate, you must follow that. It is a criminal offence to obstruct police, and it's a criminal offence to interfere with witnesses in the course of a police involvement. And both may arise if you are doing a parallel investigation. The police will be genuinely concerned that the evidence may be tainted, or as they would say, the trail may go cold. But this doesn't mean that they should be waiting for weeks and weeks and weeks to have the time to get round to it. If the police are involved and if they ask you not to investigate, you should desist. But you should keep pressure on them to say, when are you coming? When are you going to get on? And if you don't, we may well change our mind about not investigating ourselves. Be careful, document it. But very often, local authorities involve the police more as a way of kicking the matter into the long grass. And they can say to the press, well, there's a police involvement. And then everybody assumes the level of activity and the level of concern is much higher than it really is. In many cases where we've been involved, the police have actually done nothing more than seizing a load of documents, visiting the home, and then not really taking much more action. Do consider instructing lawyers. It's probably worth it taking advice from your lawyers about what's happening in a general way, and then making a decision about whether you need the lawyers to be with you or to support you or to correspond with you, or whether that may inflame the situation. Sometimes lawyers are better in the background. I find that lawyers who attend meetings are usually constructive and helpful. They're thought to be aggressive and confrontational, but actually lawyers can help people focus on the issues, help them focus on the evidence, and bring matters to a height. Ensure that the tone of your response is firm and accurate, but not overly defensive. You do not want to appear to admit things unless you're absolutely sure that they need to be admitted. And even then, bear in mind that there may be the risk of criminal sanctions coming later. So you don't want to say anything at that stage, which may be regrettable in a criminal sanction. You have a complete right not to answer questions in a criminal setting and not to self-incriminate. Next slide, please. Pushing back. Perhaps that's a rough term. You need to push back if you feel your position is not being adequately reflected. Protect your position. And something that you'll be faced with from an investigator who has predetermined the outcome of the investigation needs to be firmly responded to. Where's the evidence? Why do you say that? Why are you drawing that conclusion? Because it is too easy for someone who is appointed to handle a safeguarding investigation to skip lightly over the first step, which is what has happened, what has occurred. I mean, we've had cases where people rush to put the most extreme interpretation on what has happened. They very often describe what they say as abuse as sexual abuse, when in fact it couldn't conceivably be any such thing, because they are enthused by possibly uncovering something that is greater than it is. Remember to put the local authority to proof, as I said a moment ago. Local authorities have a duty to investigate. They must be respected. You must work with them. but they do not have the same powers as CQC. They do not have the power to take over your business. They do not have the power to force entry. They do not have the power to demand facilities or to demand copies of documents. Obviously, you want to be seen to be cooperating, but they may well start to conduct an inquiry in a way which is itself disproportionate. How many people are coming to visit you? Are they coming at reasonable times of the day? Are they interfering with the running of your business? All of these things are things you need to take carefully into account in how you respond. And if you and your lawyers feel that the safeguarding team are getting out of control, perhaps because they're concerned that they might be criticized for inaction, then the time is to take steps to control them, possibly restricting entry, possibly demanding to know what they want to see, and possibly demanding to have agendas for meetings or whatever. Safeguarding is supposed to be a fact-finding process. It is not supposed to be a quasi-criminal prosecution against the provider of services. And the most important thing that starts is to find out exactly what the facts are, where there are doubts, where there is clarity, and to go forward on a properly informed basis. We have far too many cases where people make a supposition at the beginning, which becomes the perception of truth if it's not properly pushed back upon. Next slide, please. Which brings me to criminal sanctions as we draw to an end. Safeguarding concerns can very well escalate into criminal activities with the police or with the CQC. There are significant criminal offences under a number of statutes for the ill treatment and willful neglect or willful neglect of people within care or healthcare settings. Those allegations and those criminal prospects can be made against individuals who are responsible for the care, or they can be made via the CQC as an institutional allegation against the way in which the particular care service is run. The principal police investigations, ill treatment and willful neglect, can involve direct acts and neglect. Bear in mind that is, apart from reputational damage, a provider who is charged and convicted in this field can face an unlimited fine. Individuals can face a jail term. So this is very serious. Next slide, please. It's difficult to prosecute a provider as opposed to an individual who is said to have abused. If the police are going to prosecute under the legislation for ill treatment and willful neglect against the provider, they essentially have to show that an individual within the provider who is the controlling mind of the provider has been directly involved in the allegations in the circumstances of ill treatment or willful neglect. And this could involve, particularly in a small home, a provider being seen to turn a blind eye to things that come to attention. And not taking the appropriate steps, both to react and to manage staff and to manage the delivery of care. The CQC can prosecute more for systems breaches. They can prosecute under various sections of the fundamental standards, particularly Regulation 12 Safe Care, Regulation 13 and Regulation 14, meeting nutritional and hydration needs. Those are prosecutions that can be brought, and essentially the ability of CQC to prosecute and convict is at a very low bar. The criminality is significant, but magistrates' courts hearing these cases, and it will always be a magistrates' court with CQC, then magistrates' courts tend to start by believing that the specialist regulator must be correct in its allegation that what is said amounts to a breach. The fines can be very substantial, but it is a systems breach, not a direct allegation that the particular member of the provider company has done something themselves. That may arise separately, and that would be more of a police investigation. Next slide, please. The fines in the system can be very substantial. There has been a history of CQC trying to bring in the health and safety guidelines on sentencing, and that is not necessarily the right course, but magistrates have taken a varying action. Just in a very recent case in the last few days, where there was a death following a failure to manage a falls risk and the consequence of falls, a provider was actually fined £200,000, which is a significant sum of money. Now remember, whilst you can insure against the legal fees you incur in defending these proceedings, you cannot insure against a criminal penalty. So £200,000 has hit that provider in their uncoverable pocket. In order to bring a prosecution under these sections, CQC must show that what occurred produced a significant risk of avoidable harm, and that has to be shown. But in many cases, that will not be that difficult, particularly if there are pressure sores, there are bruising, there are broken bones, there are admissions to hospital. So this should not be dismissed as fanciful, and for others, it's a very real risk, and it can start out from the information that is disclosed as part of a safeguarding investigation. Remember, the police will be part of the stakeholder group that are on the safeguarding team, and they will start to take their action in an escalating way, viewing how they see the facts, how the investigation goes, and indeed how the provider has run the service and reacted to the allegations. So it's a very serious matter, and it is becoming more significant. So that concludes my part of the presentation. Thank you for listening to me.
Thank you, Paul and Nythan. That was really helpful. A good mix of theoretical information about safeguarding and also some really helpful practical tips there from Paul on how to manage such investigations. And whilst the two of you have been sharing your knowledge, we've had a slew of questions in. So I'm going to direct a couple to you, if that's okay. The first one is actually two different people have come in with a very similar question. And I'm going to direct this to Paul. It's around data protection and requests for sensitive data. So one person has asked, we have some authorities who believe that safeguarding requests for sensitive data overrides DPA principle. What's the panel's view? And another person has said, we've been asked twice recently to share all the evidence we have gathered in safeguarding investigations, for example, interview notes, etc. It's my understanding we are not required to share these, and that our obligation is to investigate and report to the local authority and others on our findings. But this person would like to hear your views on that, Paul. So really two questions, both about sharing sensitive data in the course of safeguarding investigations. What's your view?
Thank you, Jenny. I hope I've unmuted. Let me know if I haven't. This is a very sensitive issue and a very difficult issue, and people in public authorities, in the police and elsewhere, tend to assume that they have a right to ask for anything and everything that occurs to them as part of the investigation. That is not the case. The CQC have wide and extensive powers to ask for information, and they have it under Section 64 and Section 65 of the Health and Social Care Act. But local authorities investigating safeguarding concerns and those who respond to their requests are subject to the general law in the same way as anybody else. So if you have information which, whether it is relevant or not, or whether you consider it might be relevant or not, is also sensitive and confidential to someone else's interests, such as, for example, notes taken during disciplinary interviews or steps leading to employment action that may be taken, there is a clear entitlement of employees to expect their employer to keep those matters confidential. There will be confidential issues about the particular nature of the patient's care or the service user's care and treatment. Those are confidential to the service user. They shouldn't be disclosed to anyone unless people have a genuine cause for it, unless they have, but the CQC have their rights. Local authorities and others investigating genuinely under the law have rights to demand to override some of the GDPR and data protection obligations if it's relevant to the course of the investigation. But one needs to look at all those circumstances individually. Even the police, if they want to seize documents generally under a warrant, need to have specific authority under the warrant to get personal information. So I think that the answer to the question, without going on too long, is consider every request very carefully. Certainly discuss it with your lawyers. Don't assume that it's correct. Well, we had a case recently when a police officer asked for a whole lot of patient records and disciplinary records. And when, after our advice, the provider said, I think you need to go and get a warrant, the police officer said, well, that's a bit inconvenient. Why don't we just agree to do it anyway? Actually, he went away and never came back. So some of these requests can be seen as a bit of a trial. Take legal advice, be very careful, and be very careful with whom you're dealing. Make sure you don't obstruct those who are entitled, but do not just release information that may affect others' rights.
Thank you, Paul. That's really helpful. And we have another question now for you, Nythan. Somebody is asking, how should we as providers be conducting internal investigations into safeguarding concerns?
Thanks for that question. So I think it's important that you have an independence. The person that's leading the investigation is independent of the concern that's raised against you as a provider. Now, normally the registered manager might be the person that is the best person to do that, but if you are a member of a bigger group, you might consider getting someone else in, external from the particular home, to conduct the investigation for you. But if you're a smaller provider, perhaps the registered manager is one of the people that are best placed to do that. The critical point, though, is that there's a lack of bias within the report. So whoever is conducting the report isn't as invested in the particular circumstances in respect of the safeguarding concern. We would say that instructed solicitors might be helpful to conduct the investigation, or to give you guiding words in respect of how you would carry out the investigation itself. I think you should begin with the allegation itself. You should gather evidence, the care records, care plan, any issues around whatever the safeguarding concern is. And then you should take statements from individuals involved in the care of the person that's subject to the safeguarding concern. You should be careful to inform the people that you're speaking to not to speak with others, so we don't have any contamination of any evidence. It's so far as you possibly can. And when you come to writing the report, you should present the facts as you find them, and also refer to care records with the facts that you're putting to the investigation report. It's not always going to be possible for you to cover off every issue that is found within a safeguarding concern or allegation. There may be some unexplained areas. And what you can do when you're writing the report is put in explanations insofar as you know, and refer back to the evidence that you found and the statements that you've looked at. And a useful tip at the end as well, even though it's not necessarily required when you're conducting the safeguarding investigation, but it will be helpful to put in place any issues that have been raised in the safeguarding allegation, any mitigation points that you can put in. So even if you're not particularly at fault for the particular issue, if you put in some steps that you will put in place to ensure that any issue that has been raised will be covered off in the future, then that will help reassure the local authority and CQC indeed that any issue that's been found has been covered off and wouldn't be an issue in the future, even if the position is that there was no issue in the first place. And the other critical point as well is whenever you've done your investigation report, it will go through to local authority. You may be called to give evidence before a panel. But when the safeguarding investigation report has been concluded, don't accept that as just being, that's it. There's nothing more you can do at that point. If you've still got issues at that point, you should be interacting with the safeguarding investigation throughout, not just in that initial response that you've given to the Section 42 safeguarding investigation, but you should respond and you should challenge as necessary. It's a local authority, it's a public body, that they do really have to take into account any issues that you raise and flag with them. But I hope that answers the question.
Thanks, Nythan, that's helpful. We have time for just one more question. This has actually come into email, and I'll direct this to you, Paul. So if I'm looking down at my phone, I'm not posting to Instagram, I'm just reading the question. The process of when social services speak to families about a specific safeguarding and ask leading questions such as, are you happy with the care? Is there anything else you are unhappy with? So this person is giving an example of communications between the local authority and families. In essence, we don't find the process supportive. It feels punitive. We are often harassed to provide copious amounts of information in short timescales. Then the outcome from their side can take weeks. In our experience, it can even take months, actually. I think my question is, how can we take back some control in these situations and challenge the process more? So that speaks to what you were presenting on, Paul, really, in challenging and taking control.
Thank you, Jenny. Yes, that's a really good question, and thank you for raising it, because the local authority officers can speak with force and power so that one perceives they have more rights than they actually do. You should certainly carefully consider whatever they ask for. If you think it's disproportionate, if you think the time scale is too short, if you think that some of it may not be relevant, if you think, as we were saying before, that some of it may be confidential or protected, you should say so, and you should control the issue. If you're having meetings, you should always demand an agenda in advance. You should also, if there are going to be meetings that may make allegations, you should ask to be told in advance the substance of those, so that you don't have to respond by saying, well, I need to go back and investigate that. But yes, you can take control. You don't have to be bullied, and you do need, with advice usually, to, at the beginning, to manage this just as you would manage a potential investigation by the police. What you do at interview is important, whoever is conducting the interview. But remember, there are limits on the powers of those who are seeking to follow up on inquiries. And yes, you're right. Local authorities are very bad sometimes. Some of them are very good, but some of them are very bad at the way in which they frame questions. They ask leading questions. They ask questions which are loaded towards a particular answer. And if that has happened, you need to raise that, you need to challenge it, and you need to look for the substance of the allegation, and you need to come back time and time again to, what are you saying? Is this hearsay? Is there some fact? What do you need us to look at? When did it happen? What time of day did it happen? What exactly is said to have been seen? Because a number of times people make assumptions about what they see. And just a very short anecdote to close. We had a case where one old lady was accused of hitting another old lady in a lounge. It transpired that that was nothing of the case at all. What had happened is everybody entered into the lounge. The first thing they saw was one lady bending over another lady who was lying on her back. When proper investigations were conducted, she was actually trying to help her, but the enthusiastic first responders made an assumption of the highest degree of guilt that they possibly could. And that is the sort of thing that can stigmatize homes, it can stigmatize individuals, and it needs to be rebutted and examined and exposed for what the substance is, rather than what somebody assumes and then wishes to put forward as their explanation for what may be a very innocent event, as I've just described. I hope that helps with your question.
Thank you, Paul. That's really helpful. I'm afraid we are just out of time. We have a dozen other questions, and I think what we will do is provide a Q&A to the questions that we haven't been able to answer live, because safeguarding really is a can of worms, and we could sit here and discuss this all day, but we all have care business to run, I would imagine. So thank you, Nythan. Thank you, Paul, for such information and guiding us through what can be a really difficult process. And thank you, everybody who's joined us on this webinar. We're really grateful for your attendance, especially at the moment when we know that you're busy with many other things. We hope it's been useful to you. And if you'd like any more information, you can go on our website, as I said, and access the link that will be available. And a link will be circulated to all participants. As you will have seen just in the previous slide, we have some more webinars coming up in our series. We have inquests coming up on the 25th of November. And we have Provider's Choice, which is happening on the 10th of December. So if you have any ideas of topics that you'd like to discuss, please email us and let us know those issues, and we do our very best to cover it off in a very general presentation on the 10th of December. If you want more information about what we do and the kind of work that we do, as well as helpful articles on sectors of the law that may be relevant to your business, please visit www.ridout-law.com. We're also on Twitter, LinkedIn, and as I've mentioned before, YouTube. And you can also sign up to our mailers to get the most up-to-date information. As I've said, you will all be receiving the slides and videos in an email after this event. And to close, I'd like to say thank you very much again. It's been lovely to have you join us, and we hope to see you again soon.